All right, everyone, somebody's going to go to jury trial today. So attorneys, you know the rules, please confer. Thank you.
Benjamin, we approached it very briefly. Sure. I have that motion for which is a capital, is set on Monday the 19th. Our expert hasn't been able to see him, so he filed the motion for continuance. Can I bring him like Wednesday and we could do it? You want him here, right?
Yes. Yes. Well, he can do it by Zoom. Is he available by Zoom today?
The defendant?
Yes.
I imagine. I don't think he's doing anything.
All right. Well, talk to Ms. Ferguson and see if he's available by Zoom.
Okay. All right.
All right. Are the parties ready on Noel Rodriguez? Is he in custody?
Yes, ma'am, he's right here.
Okay.
Good to be here early with you, Judge.
Oh, great. Good having you here.
Yeah.
Let me just check. Do you know if a PSI was done on this or no?
Yes, ma'am, you want a compliment?
All right, thank you. All right, court is calling 2024 CR 00899 State versus Noel Anthony Rodriguez. Mr. Rodriguez, if you'll come down, if I can have parties announced for the record for the state.
Robert Robach for Noel Rodriguez.
And are you Mr. Rodriguez? All right, you entered a no contest plea on October 16th, 2024 to the offense of choking. According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. The state opposes your application. They're taking in consideration 2024 CR 008862. Have both parties had a chance to review the PSI report, state?
Yes.
Defense?
Yes, ma'am.
Any objections to the PSI report, state?
No objection.
No
Defense?
objection, Your Honor.
Have both parties had a chance to review the TAP evaluation, state? Defense?
Yes, ma'am.
Any objection to the TAP evaluation, state?
No objection.
Defense?
No objections.
Any witnesses, state?
No witnesses, Judge.
Defense, any witnesses?
No, ma'am.
All right. I'll hear argument then. State you're opposed?
We are, Judge. Given the defendant's criminal history, this is not the first felony that he's been committed or that's been convicted of. He has committed multiple acts of family violence, and one in October of 2023 was a choking and strangulation. However, that case was dismissed because the complainant waived prosecution.
And who was the complainant in that case?
It would have to check actually, Judge. He has been convicted of an unlawful carry of weapon and assault in 2021, and I can check the victim on that one momentarily. He also has been convicted out of state, out of Wilson County, for an assault second. He was given probation in that case. However, he did not complete his probation. He was revoked on December of 2023. And he is pleading to one case, which is the offense date of the 6th of June of 2024. It wasn't until he bonded out 3 days later, he committed another offense on June the 9th of 2024, also an assault second. Given his criminal history, given the fact that he has been given an opportunity to get probation in Wilson County and has been revoked, the state does not believe that he would be a good candidate for probation. And we ask that you sentence him to no more than 10 years TBC.
Right. And while the state is finding the list of the complainant on the other cases, defense, I'll hear your argument.
Yes, Judge, defendant's been in custody for 168 days. He has no felony convictions that I know of. He has 2 children. He does need some mental health assessment. The complainant in the case, Megan Rodriguez, in the report states that she's in favor of probation. I think with the proper guidelines set forth and conditions that the probation recommends that he's learned his lesson. He's taken anger management courses, 12 of them. I'd like to give you copies
Any
of those.
objection to the court reviewing the certificates?
Okay.
So has spent his 168 days productively in custody and is ready to return. He has to support his two children, needs to get back to work. And I think that any other conditions that you might give him that are outlined in the probation report, he's willing to follow follow your rules and not come back here.
All right, defense? I'm sorry, state.
To answer your previous questions on the first assault, the misdemeanor conviction was a different complainant. On the assault, choking strangulation that occurred on October 26th of 2023, where the case was dismissed for complaining waiving prosecution, was the same complainant as this case. It has a different last name, but I confirm it's the same date of birth.
All right, and then the case that you're taking in consideration, the ABI second, who's the complainant?
That one should also be the same.
All right, is there anything you wish to say?
I'm very more.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record. All right, so what was this argument about?
I can't even remember that day.
All right, because according to the stipulations, it states that the complainant was sick through food poisoning, and she asked for your help caring for your child, which was crying. And it says that you became angry with her. So she ended up taking the child and asked you to fix a bottle for the baby. You were still angry and you were upset with her requests. So she put the child down and went to get the bottle for herself. You wanted to leave the residence and tried to get the car keys. She would not give you the car keys, so you slapped her. She defended herself. You hit her in her chest, then placed your hands around her neck, choking her. So you don't remember any of that?
No, Your Honor, I was putting my daughter to sleep that night, and she had been in the restroom. I was having difficulty putting my daughter to sleep, and I had asked her to help me. She ended up picking up our daughter, and she started rocking her, putting her to sleep after that. I was frustrated, but I wasn't trying to leave at that point. It wasn't until she had started getting physical that I was trying to leave. But at no point did.
Well, it says here, the victim stated that she was strangled by her boyfriend. She sustained injuries to her neck and chest. While speaking with the victim, I observed scratch marks and redness to the left and right side of the neck and redness to the chest. I observed bruising to the left and right biceps and underneath both arms of the victim. And they photographed the injuries. I also photographed a large amount of black curly hair clippings that were in the bathroom allegedly left by the suspect prior to him fleeing the location.
I had cut my hair that day.
All right, well, in the report, they make it seem as though you choked her and then you cut your hair and then you left.
That day, it's hard to recall that day, but I know that when she had started choking me, and
Oh, so you're saying she started choking you first?
yes, ma'am.
Okay, you may continue.
After that is I started going back at her, and I regret it deeply. It's just
Okay. All right, any questions?
No, Your Honor.
State any questions?
Just a couple, Your Honor. Mr. Rodriguez, you are applying for probation, or you're asking the court for probation. Okay. So you understand that the first step of probation is accepting responsibility, right? But when you spoke with the probation officer, when this report was being prepared, he did not want to talk about his, right?
I told the probation officer that I couldn't recall it fully.
Okay, so you did say that you had difficulty remembering, but then you also said that you'd rather not talk.
I didn't want to talk about it without remembering it fully.
Okay. But you do remember that she started it?
Yes.
Okay. How is that accepting responsibility if you're blaming it on her?
I'm taking responsibility for my actions. I shouldn't have reacted the way that I did. I should just walked out of the house once things started getting physical.
But you understand that you've been placed on probation before, right?
Yes.
And the idea is probation should give you the opportunity to rehabilitate yourself and avoid engaging in any more criminal behavior, right?
Yes, sir.
So you didn't complete probation in Wilson County, right?
No, sir.
Okay, and then you committed an offense on June the 6th, right? Of 2024? The choking?
Yes, sir.
And then again on June the 9th of 2024, right?
Yes, sir. Or June 9th. That day I didn't really do anything. I had OD and my wife, I called the cops saying that she needed ambulance.
No further questions, Judge.
All right, anything else from the defense?
I think, Judge, the fact that he took these anger management courses shows that he wants to comply with the terms of probation if you give it to him.
All right, the court is going to deny your application, find you guilty. Does anyone wish to speak to the cap?
Judge, in light of the fact he has 2 children, and he has a household that needs him, we request the cap be the minimum of 2 years.
All right, state, what are you requesting?
That's no more than 10 years.
All right. Mr. Rodriguez, I want you to know that I listened to the arguments of both sides. I listened to your testimony. I read the stipulations again, because I'm not the one who accepted this plea. And I also reviewed the TAP evaluation and I reviewed the PSI report. This is what the court is going to do. Court is finding you guilty. There's an affirmative finding of family violence. The court will give you credit for any time served. Taking consideration 2024 CR 008862, there's to be no contact with Megan Lindsay Garza, no unsupervised contacts with minors. I'll recommend the therapeutic community for you. The therapeutic community does not increase the amount of time that you serve. For example, if I were to send you to 10 years, the fact that you're in the therapeutic community will not extend you beyond my sentence. Do you understand?
Yes, sir.
I do not have jurisdiction to force them to place you in the therapeutic community, so you'll have to request it. But it will show in your judgment that the court is requesting the therapeutic community for you to address any drug or alcohol issue or any mental health issues. And the court will sentence you to 6 years in the prison. Did you review the document? Yes?
Would it be possible to get the no contact order dropped?
No. And let me explain to you why. I don't like for people to think that I just do things just to do things. For example, because it's 6 years instead of 10, there's a reason for that. I took in consideration the mitigation evidence. I took into consideration what the complainant wanted, and I took into consideration your criminal history, and I took into consideration the classes that you completed. With regards to the no contact order, there's an issue here. And that issue hasn't been solved because this is not the first time that you were accused of assaulting her. This is the first time that I guess she's given a statement to the police about it and come to court about it and continued with it. So obviously that relationship is not working. I don't have you on supervision with the court because I'm sending you to prison. If I had you on supervision, I would still have the no contact order, then maybe slowly consider lifting the no contact order. But not in this case, the answer will be no. All right, so that's 6 years in the prison. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
You signed.
All right, we can go off the record. I know 6 years is a lot of time. It's a lot of time away from your children, but you can't continue to commit actions that you commit, violent actions, and then not expect there to be any consequences. When you're released from prison, if I'm still here, you need to make sure that you take care of your drug issues and you take care of your mental health issues. If you cannot find a place, come back here and I will pick up the phone and call someone to help you. You understand?
On my release, I plan on going to CHCS, Center for Healthcare Services.
Okay, that's great.
Get my primary care doctor back on medication.
All right, awesome. Make sure that you stay on top of that, okay? Up to you.
Thank you, Judge.
Thank you. All right, who's here on Emily Flores?
Looks like you're overdue for a carpet as well, Your Honor.
Oh, let me just tell you, see, that's a sore, Vashon, he doesn't know how sore of a spot that is.
Did I not have brought that
Oh,
up?
no, you can bring it up, but here's the thing. Yeah, bring it up one more time. Here's the thing. Do you know it costs taxpayers a lot of money to move from one courtroom to another? So I used to be at the courtroom at the
Right.
other end. Well, when they had that flood, the great flood in the DA's office, all that water came down in that courtroom and it soaked through the carpet. And because everybody was on vacation, nothing happened with the carpet, right? So it was soaked in my office, the coordinator's office. The coordinator's furniture was ruined. And we kept calling, what's the name of the guy? Who's in charge with that? In charge of building maintenance? All right. So anyway, the guy in charge of building maintenance, he's the person who was smoking on the balcony who got the door. Well, anyway, I ended up calling him saying, hey, this carpet needs to be taken
Eddie?
out. No, not Eddie. Eddie wouldn't do that. So I called and said, the carpet needs to be taken out. And you know what he tells us? There's nothing wrong with that carpet. Like, it was flooded. The carpet needs to
Yeah.
be taken out. So every Monday when we would come in, the entire office would smell like mold and mildew. So I kept writing letters, sending emails to commissioners and everybody. Nothing was ever done. And then my toilet in the judges' chambers would never work.
Mm.
Nothing was ever done with that. So, and the carpet in the courtroom, nothing was ever done with that. So for 4 years, I was sending emails, phone calling, saying, hey, can you all not afford the deductible? Isn't there insurance on this? Would never do anything. So I said, look, it will cost you more money if I move courtrooms to the end of the hallway than you just
That's why
replace.
you moved?
That's why I
Oh,
moved.
man.
Because normally I wouldn't move. I don't,
Better window view or something.
oh, no, I don't like wasting taxpayers' money. So that's why I moved. But it's nice to have a view of the cathedral so I can pray.
Sure. I'm sure you'll get a new one, Judge. They're all getting one.
No, they're not gonna give it to us.
Really?
No.
Wow. Sorry I brought it up.
That's okay. I will believe it when I see it. Vashon, the struggle is real.
I've just put my hope and faith into the system that you're gonna get a new carpet, so.
There's a toilet that's out in the jury room.
Oh, that's gotta get fixed.
Oh, you know how long we've been waiting for that? How many months?
Oh, Judge, that's horrible.
And then,
Eddie, tell Eddie
oh,
They don't
no, you
get
can't
them.
do it that way. You have to go through
the channels.
the channels. And we've already gone through the channels. And then it took us 2 years to get light bulbs for this courtroom when the light bulbs went out. So, yeah.
Wow.
So is there anything you would like to discuss to brighten this Monday?
I would like to discuss that Miss Flores has been accepted into the PTD program.
Awesome. Norma, sorry you had to hear that. Your attorney is the one who brought it up. Thank you for dressing appropriately for court and being on time. Ms. Ferguson, I need a 30-day reset for PTD. All right, we'll be back on January 16th. Make sure you keep up with everything, okay?
Yes, ma'am.
Thank you.
Thank
Once you
you.
sign the reset form, you're excused. Scott, anything else you want to bring up?
No, Judge, I'm afraid of that.
Who's here on Samantha Rama? I think this is Criminal Trial Division.
Yes.
Hello. Have you all conferred?
Yes, Your Honor.
Do you have all discovery?
Do we have all discovery? I think so. We're not sure.
All right, has an offer been tendered?
Not yet, you're on contact the complainant and asking.
All right. All right, when we come back, you all need to make sure you have all the discovery. I don't know the discovery unless you all want to come back here for a hearing and I'll go through the entire prosecution guide. Okay, won't be necessary.
No, it will not.
All right, Norma, recall this for January 6th, please.
6th, Your Honor.
Yes. All right, thank you for dressing appropriately for court. Once you sign the reset form, you excuse.
Thank you, Your Honor.
Yes, discovery and status to tender an offer. And let me see what page she is on. But Sean, it's a shame we don't have that email again where emails were going through to everybody in the entire county. Yes. Hi, Richard.
I went to a Christmas party on Saturday.
Mhm.
And my friend that was throwing the Christmas party has nothing to do with the law. She's a nurse. And she goes, oh, there's a judge that's on TikTok or something. And I love her. She's awesome.
Oh, thank you for the support.
And I was like, and she's from here in San Antonio. She goes, yeah. So I knew exactly what she talked about.
Oh. And you know what? I'm telling you, I think the process should be transparent so people won't think they can come in and it's like the practice or something.
Right. Yeah, totally different.
Yes. All right, Janessa Salazar. Good morning. Good morning. Good morning. So are you already on the motion to revoke?
Yes, Your Honor.
Okay. Yeah.
Office asked for a motion to withdraw.
Okay. Why?
Because I reviewed the circumstances of the offense and the motions, and I don't think we can prove them.
All right. Let's go on the record. Court is calling 2024 CR 3821, State of Texas versus Janessa Salazar. Can I have parties announced for the record for the state?
Your Harris Edelman.
Defense?
Danielle Cranberg.
All right, this is the motion to revoke, and off the record state you are tendering or asking that the motion be withdrawn. Is that correct?
Yes, Your Honor.
And why?
The violation allegation.
All right. Then the court will sign the motion to withdraw. All right, and then with regards to the PF case, what's happening with that? The theft of property.
I think she has a different attorney listed for that one.
All right. Oh, that's Mick Aguilera. So if you'll just wait in the courtroom a little bit, could you call Mick to see if he can come over very quickly?
Yes,
And then we'll take care of that. All right.
Thank you.
Judge, on her probation case, so, we would like to possibly alter and amend conditions to
Yes.
include, mental health evaluation, make caseload placement, and moral recognition therapy.
All right, we'll do a Mick evaluation out of custody. And then in regards to the MRT, do you think the MRT is needed until we discover what's going on mentally?
I do.
All right. So MRT. All right, just have a seat. Thank you. Mark Anthony Aragon.
Yes, Judge, we're ready.
Good morning. Just give me one moment. All right, court is calling 2022 CR 8245 and 2022 CR 3008, State versus Mark Anthony Aragon. Can I have parties announced for the record for the state?
Megan Gallagher, state.
Robert Maurer for defendant, Your Honor.
And are you Mr. Aragon?
Yes, ma'am.
All right, off the record for a moment. Excuse me, sir, you're gonna have to find a seat for security reasons. Thank you. All right, we're back on the record. And each cause number, you entered a plea of guilty. The court ordered a TAP evaluation and PSI in each cause number. This was actually set for a hearing, but your client was a no-show. And so a warrant was issued for his arrest. And cause number 2022 CR 8245, according to the plea bargain agreement, the state is silent on your application. There's to be restitution to Express Super Gs. This is the rank concurrent with 2022 CR 3008. And in that cause number, according to the plea bargain agreement, punishment is to be assessed at 3 years in the prison, and the state is silent on your applications. Have both parties had a chance to review the PSI report? State?
Yes, Judge.
Defense?
Yes.
Any objection, state?
No, Your Honor.
Defense?
No.
Have both parties had a chance to review the TAP evaluation? State,
Yes, Your Honor.
any objections?
No, Your Honor.
Defense?
Yes, no objections.
All right, state is silent. Defense, do you have any witnesses?
Judge, on my client's behalf, I'd ask the court to consider granting his application for probation. And if the court decides that's not appropriate, I just ask the court, give him credit for time served and honor the plea bargain.
All right, is there a reason why he didn't show for court at his sentencing?
I have no explanation, Judge.
All right, would you like to say anything?
I had just lost my job and I.
No. I mean, if you want to say something, you can say something, but you're going to be placed under oath. And if it's something that is factual, the state will be able to ask questions in regards to that. So do you wish to say anything?
No.
All right, then in cause number ending in 8245, according to the PSI report, they have a restitution amount of, I believe, 2,500. Is there an agreement to that restitution amount?
No, Judge.
All right, other than their request of that amount, state, do you have any documentation? Because in the PSI report, I just see where they're saying tanks were stolen and they state it's for $2,500, but there is no receipts or anything of that nature.
Yes, Your Honor.
No problem. And while she's reviewing that, and cause number 2022 CR 8245, the court is going to deny your application. Court will find you guilty. The court will sentence you to 1 year in the state jail facility, give you credit for any time served. This will run concurrent with 2022 CR 3008. And any updates, date? All right, there's going to be restitution to Express Super G's. And the owner is listed as, there's to be no contact with 227 Enrique Barrera Parkway. Or Express Super G's. Anything else in that cause number with regards to sentencing?
No, Judge.
And then in cause number ending in 3008, the court is finding you guilty. Sentence you to 3 years in the prison. Give you credit for any time served. And this will run concurrent with 2022 CR 8245. Anything else in that cause number with regards to sentencing?
No, Judge.
All right, we can go off the record and state you're excused. Here's the thing, and I'm sure your attorney will tell you this. Yes, I review people's history, but the number one thing you must do, if you have sentencing, you have to show up. Who knows what would have happened? Maybe I would have given you probation, but the fact that you don't show up combined with your criminal history, that's a recipe that tells me you're not going to do well on probation. You understand?
Yes, ma'am.
All right, good luck to you, okay?
Thank you, Judge.
Thank you.
Thank you. Mick Aguilera.
Oh, does that have my client's name on it?
Next pile.
Yeah.
It's gonna take me a while because I'm putting dates in.
For Stephanie, she like had surgery on her foot, so I offered to run them down. I
Oh
didn't
my
check
gosh,
them
how
on
is she
her.
doing?
She's good, but it's like her first day without the scooter,
Mhm.
and she was gonna hobble all the way down here, and I'm like, girl, I'll just
Oh,
take
no.
this for you. So I apologize, Judge.
Oh, no, I'm just joking. There you are, have a good one. All righty. And what's your client's name?
Janessa Salazar.
Did I see the file on Janessa Salazar? It's the PF case.
I understand they withdrew the MTR.
Yes. So, Janessa Salazar, if you can come forward. All right, on this case, it's a PF case. It hasn't been indicted. So we can bring you back at the request of your attorney. Otherwise, you're not going to be brought back unless and until it's indicted.
Yes, ma'am.
All right, and are you okay with not receiving a reset date?
Yes, Judge.
All right, then you are excused.
Thank you. so
Make sure you
much.
speak to probation before you leave.
Yes, Your
Thank
Honor.
you.
Thank you, Judge.
Thank you.
Yes. Yes. On a completely unrelated note,
Yes.
2 okay on the 18th?
Yes.
Okay. I'll see you on the 18th if not so.
Okay.
Thank you.
All right, Sarah Gutierrez.
Sarah?
You know, they had a Hall and Oates song, Sarah Smile. He doesn't know what I'm talking about. He's too young.
That's a great song. I do.
Isn't that a fantastic song?
Whatever, man. Really good song.
And you know, that song is about the person who would be writing their songs. They broke up, but supposedly they're still good friends. But a lot of her hits are from
Really?
that time.
Yeah.
And they said the same thing about Lionel Richie. A lot of the songs that he wrote, it was with his wife. All righty. So they tell me your case has been dismissed.
Oh, thank God. That's like a Christmas miracle. That's all I wanted for Christmas.
Happy Festivus.
Oh my gosh.
To the rest of us.
Thank you so much, Judge Boyd.
All right, you're
Thank
so
you.
welcome. And thank you for always dressing appropriately for
I could
court.
have dressed better today. I'm
No, no.
getting over a cold, so.
No, that's fine. So make sure you don't come back here for anything else unless you're just coming back to visit, okay?
I'll bring you some flowers if I do.
You made Sarah smile, Your Honor.
You did. You did. Thank you so much.
You're welcome.
Thank you.
And counsel, I don't know if they have a copy of it in the system or not. If you want to print out for it to give it to her, you can request that.
Thank you.
All right, thank
Awesome.
you.
Thank you.
Have a good one.
Commander,
Hi.
permission to approach, Commander.
Well, just give me a moment. Let me put this in the
Yes, ma'am.
system. All right, I'm sorry, counsel, in front of you, the person who's picking a jury.
Oh, yes, Judge.
Yes, you're doing jury selection?
Yes, ma'am.
Is your client in custody?
No, which one?
Anthony Villarreal?
Yeah, he's right here, Judge.
Anthony Villarreal, if you'll come forward, please. He has an aggravated robbery, evading arrest, detention vehicle, and burglary of a habitation.
That's a different one, burglary of the habitation only, by assault.
Oh, you're only on the burglary of a habitation?
Assault. There should only be, there must be two.
Yeah, there's two different, so my client's in custody.
Ah. So there are two Anthony Villarreals.
Yeah,
today.
I believe so. That's what it sounds like.
All
yeah.
right, so are you the Anthony Villarreal? So you're the Anthony Villarreal with the burglary of the habitation?
Assault, yes,
All
correct.
right, thank you. You may step back.
Good too.
Oh. Oh, that's okay. I mean, what are we to do? It's two names. All right. So, you're in jury trial?
Yes, ma'am.
Oh, which court?
186.
And I asked, not that I don't believe that you're in jury trial, but I do. But I like to put everything down in the notes so people will say Charles Gold was in jury trial. That's why we couldn't do a jury trial. So you were supposed to have your jury trial today, but can't have it because he's already in trial
Mhm.
and can't be, in the words of the poet, he can't be in two places at the same time. All right, so Ms. Ferguson, what are you trying, counselor?
Right now is a decency. problem.
Okay. So Norma, if you recall this for January 6th. Okay.
Judge, I think that week, I'm supposed to be heading out. I'm off that week. Remember
Okay.
to the 11th. I think the 13th is my daughter's getting married.
Oh,
Yeah, my daughter's getting wet, so I have to do.
you have to remember that.
I do. January the 11th is that she's getting married.
All right,
So-
and do you need to be there or your checkbook just needs to be
Both.
there?
My money and she probably just wants my money though.
Well, you know, they say that Eddie Murphy and Martin Lawrence's daughter is marrying Eddie Murphy's son. And so they're joking about it because Martin Lawrence like, you have more money than I do. You should be paying for this wedding. And then Snoop Dogg's daughter is getting married.
Really?
And he said, here's $1 million. That's all you're getting for your wedding.
That's it, huh?
That's it. So I'm sure you wrote a check. Here's $1 million. That's all you're getting.
No, nothing like that.
We can recall it for the 13th.
If we do. The 21st.
21st?
Yes, sounds a lot better.
All right. 21st for jury trial.
Thank
Once you
you.
sign the reset form, you excuse. Thank you for dressing appropriately for court.
Thank you.
And counsel, just give me one more moment.
Patient guys, we're in standby.
Oh.
We're hovering.
As long as you're not running out of gas. And then who do you have?
Mine is Brenda Carpenter, Your Honor.
All right, so once they pull the file, then I'll take it up.
Yes, ma'am.
All right, Brenda Carpenter.
Yes, Your Honor.
Is she here?
Yes, she is, Judge.
Come up, please.
Miss Kristen Molnar, she said for me to tell you that she's in a suppression motion for a couple hours in the 437. And I told her that I was gonna inform the court that, and now it's not ready because I just got discovery over the weekend, Judge, tapes and other things and insufficient
Okay, I
business
don't
record.
understand what the issue that's going on with discovery.
I don't know, Judge. All I know is that we received it on Saturday, Your Honor, so,
Mhm.
and it's very intense, so I would never be dilatory, Judge. I don't, yeah, so I want Your Honor to know, I take this very.
No, I know it's not your fault or you. All right, Norma, recall this for the 21st then,
21st,
January.
okay, Judge. Thank you very much, Your Honor.
All right, thank
Have
you.
a happy
Thank you.
Christmas, Your Honor.
Oh,
Thank you for always being professional. Thank you for helping. I salute you.
Oh, thank you
Okay.
so much.
Okay.
Thank you for dressing appropriately for court.
Yes.
Once you sign the reset form, you're excused.
Thank you. Yes.
And counsel,
Yes, Judge.
I'm not going to charge that motion for continuance to you because I don't think you should have to have a motion for continuance when it's because you have not received discovery.
Thank you very much, Your Honor.
You're welcome.
Okay.